Hello, you are welcome to Company and Partnership Law class. Today, we want to look at Section 4 of Unit 2. Unit 2 is on nature and functions of companies. Section 4 of Unit 2 is on formation of company and consequences of incorporation. Session objectives. By the end of this session, students should be able to explain how to form a company in Ghana, outline the consequences of incorporation of a company, and the procedure for conversion of private company to a public company. Now, formation of company. You have to know that in Ghana, company is formed by registration of the proposed company under the Companies Act 2019, Act 992. So before you can register your business as a company, you have to register it under the Companies Act 2019 at 992. The registration is conferred by the state through the Registrar of Companies. Now, in order to form a company, you have to comply with the provisions of Section 13 strictly. Now, Section 13, 1 of Act 992 provides that the promoters should file an application to the registrar for registration, which means that in order to form a company, an application for incorporation shall be delivered in a prescribed form and delivered to the registrar. Now, what is this application about? If you look at Section 13, subsection 2 of Act 992, it gives you the content of the application that you have to make to the registrar. Some of the elements that contains in the application are the name of the proposed company, the nature of the proposed company, the object of incorporation, the registered address of the proposed company, the email address of the proposed company, the particulars of subscribers. Subscribers means those who append their signature to the constitution of the company or the application for registration. We also need the particulars of proposed directors, proposed secretaries, auditors as well. In fact, Section 13.2 of Act 992 contains a lot, and I will refer you to that provision. I've stated some of them. Now, if you look at Section 13.2H, it provides that a proposed director must make a statutory declaration that within the preceding 5 years, the proposed director has not been convicted or charged with any criminal offense involving fraud or dishonesty. The B states that a proposed director should make a declaration that within the preceding 5 years, he has not been charged or convicted with criminal offense involving promotion, incorporation, or management of the company. Now, he should also state that he has not been declared insolvent, or if he has been declared insolvent, then the date in which the insolvency was declared and the company in which he was working with. Insolvency means that when your liabilities fall due, you are not able to pay. Once you are not able to make this declaration, or you fall short of this declaration, for instance, if within the past 5 years you have been convicted of offense involving fraud or dishonesty, then automatically you are disqualified to be a director for that proposed company. Now, once the application has been completed, the subscribers must file the application to the registrar. The registrar must satisfy himself that all the requirements has been met. Once the requirements has been met, in the opinion of the registrar will require the promoters of the company to pay a prescribed fee, and upon payment of the prescribed fee, the registrar will satisfy under his seal that the company is duly incorporated. Now, it used to be that a company, before it will operate, must have a registered constitution. However, under Act 992, the fact that a company must register its own constitution has been made optional. It means that you may decide to register your own constitution in addition to the application under Section 13 of Act 992. If you fail to register your own constitution, then you will go by the default constitution that is in Act 992. Now, so you should pay attention to that. Now, the prescribed fee and the certification of the registrar of the seal that the company is incorporated is found in Section 14(1) of Act 992. From there, what is then the status of the company after incorporation? Section 14, subsection 2 provides that from the date of incorporation, the company becomes a body corporate and it is capable of performing all functions capable of being performed by a body corporate. In other words, you can say that once the company has been incorporated, it becomes a separate legal entity. Now, upon the registrar satisfying that all the requirements have been met, it is up to the registrar to issue what we call a certificate of incorporation or a copy of that certificate. Now, when that one, the certificate of incorporation is issued, it gives what, or it indicates a conclusive evidence that the company has been duly incorporated. And once that one is shown, no proceeding shall be brought in court to cancel or annul the incorporation. It means that once the certificate of incorporation has been issued, it is conclusive that the company has come into existence. Now, when you form a company, what are the advantages? The first point you want to note is that separate property. What you mean is that the company being incorporated can own its own property or can have its own property. The property of the company is not the property of the owners. The shareholders do not have interest in the assets of the company. They only have interest in the shares of the company. This is supported by the case of Macquarie v. Norton Assurance Limited. Now, the next point is perpetual existence or succession. Here, we mean that a company, if it is managed well, it will exist for a longer period of time or it will exist for the foreseeable future. It means that if you get poor management, that quality or that characteristic will not be achieved. Now, another point is that legal action. And this one, we mean that a company, once incorporated, can sue and be sued. Now, a company can institute an action to enforce its own contractual rights, and this is supported by the case of Ford versus Hamilton. Ford versus Hamilton. Now, once the company is incorporated, there is a limited liability. What we mean is that the liabilities of a company is limited in a certain sense. In terms of liability, you have to look at the type of company in question. For instance, if you take company unlimited by shares, what it means that the liabilities of the members or shareholders are not limited. So in case the company incurs losses and it cannot pay, the liabilities of the members of a company, of a limited liability company, can be the asset of the members or shareholders of unlimited liability company can be sold to defray that debt as well. When you pick a company limited by shares, it means that their liabilities or the liabilities of shareholders are limited to the unpaid cost. Unpaid cost simply means that the amount of shares that has been allocated and allotted to them, but they have not made payment to that effect. So at any point in time, they will be called upon to come and pay the remaining amount that they have not paid. With company limited by guarantee, the liabilities of the members are limited to the amount the members themselves have promised to undertake in case or pay in case the company is winding up. Now let's come to the borrowing power of a company. Once a company is incorporated, it has the power to borrow from other institutions. Now the company can take loan and use its own assets as collateral. The company can issue debenture, which is a loan, and with this debenture is used to secure loan from other companies. Now, in this case, it is only companies that can issue debenture. Individuals cannot issue debenture. So, debentures can be issued by partnerships and companies. Now, when a company takes loan, the company can use its asset to secure a loan either by floating charge or fixed charge. When a company uses its asset to create a floating charge for the purpose of taking loan, then that charge creator will not prevent the company from using the same asset to acquire another loan. However, in the case of fixed charge, the charge prevents or prohibits the company from using the same asset to secure another loan. We also have transferability of interest. Now, if you remember, when we were discussing the difference between public company and private company under section 7.5 of Act 992, we made mention that the transfer of shares in company limited by a private company is restricted. However, in the case of public company, it is not restricted. So when you take this point, you have to explain to the extent that in public companies, you can easily transfer your interest. However, in private company, even though transfer of interest is permitted, but it is, however, restricted. Now, what is then the disadvantages of incorporation? You have technical formalities. Before you form a company, you have to meet several requirements. Have a chartered accountant, have an auditor, meet certain requirements, and file different documents. In fact, you have to meet a whole lot of requirements before it could be registered. The cost involved in incorporation. When you want to form a company, it involves huge amounts of money as compared to a sole proprietorship. Now, we have lack of control. Once the company is incorporated, the management of the company is entrusted in different people, not those who form the company. So the shareholders, if they are not probably part of the management, are likely to lose control. Now we also have loss of privacy. In other words, loss of privacy. What you mean is that once a company is registered, it exposes itself to the general public so that when the financial statement is being published, especially public company, the law expects it to publish its financial statement. So you don't have anything to hide. In the case of private companies. The law requires the company to prepare its financial statement, but it is not mandatory for the private company, to publish its financial statement. However, for the purpose of attracting investments, public companies may publish their financial statements to attract investors. All this leads to the fact that there is loss of privacy. Now I want to look at the procedures for conversion of a private company to a public company. Perhaps a private company, because it is prohibited from inviting the general public to acquire its shares or deposit money. The company may try to remove that disability by converting it from private company to public company, so that they can also do what public companies are doing. For instance, to accept deposits or invite people to acquire their shares. So these are the steps. You have to convene a meeting of the board of directors and pass a resolution approving the conversion of the company from private company into a public company. Before the process can, or before a private company can converted to public company, the board of directors must have a meeting and they will have to pass a resolution. Resolution means they make a decision, and here you are looking at special resolution. 3/4 of those who are entitled to vote will vote in favor of the conversion. Now, you also convene a general meeting of the members of the company for the alteration of name clause of the constitution by special resolution. So as I indicated, special resolution is about 3/4. It means that if you get less than that, the change or the alteration of the name cannot be possible. After that, you make an application to the registrar of company for approving conversion from a private company to a public company. Once the internal decision has been made, you then have to inform the registrar about the changes or the conversion that you want to make. Now, the application to the registrar shall be accompanied by a special resolution for converting private company to a public one. So the decision that you make, you have to attach it to the application to the registrar, so that the registrar will be satisfied that the decision taken was complied with the provisions of the Act 992. The application to the registrar of company in Ghana shall also be accompanied by additional documents, such as a statement in lieu of prospectus. Once all these procedures have been followed, the registrar will issue a new certificate of incorporation as a form of a revised certificate of incorporation to the company. So when everything is done, the shareholders or the management of the company must obtain a revised certificate of incorporation to reflect the changes that has been made. That the company will now be a public company, and it must reflect on the certificate of incorporation. By way of summary, in this session we have studied formation of companies and the consequence of formation of companies. We also explained how a private company can be converted into a public company. I believe you have enjoyed the lesson. Thank you, and see you in the next class. Goodbye.